thank you for being here. And I know it's interesting being asked to put your mind back 16 years ago to try to think about where you were at the time.
At least I don't have to go back 35 years to think about where I was at the time.
That's true. That's true. It could be worse. But thinking back on this, when this controversy was put before you, do you recall your initial reaction to the dispute?
My first reaction was, I thought that Vice Chancellor Lamb had written an opinion that I liked, admired, and was more than willing to follow. And I frankly thought he went one step beyond what he needed to do to decide it the way he did. If you recall the way the system worked at that time, we used the military system when we discussed cases, meaning the junior officer speaks first, and the senior officer speaks last. So the Chief Justice then, and I assume until the change in 2013, speaking last, always hoped it wasn't 2-2 when it got to him, right? Well, the biggest surprise I had was I stated my position, which was consistent with both what Chief Justice Veazey wrote and what I wrote in the dissent, and then I was stunned when there were 3 different opinions right after me. And it went to Chief Justice, and then the Chief Justice basically accepted in his own much more eloquent way the position that I agreed with. Not because I had stated that position, but because he had the same view I had. But I was really surprised at the fiduciary out prescriptive requirement. I didn't have that concept in mind, didn't think about it. I was all focused on whether or not you put a board of directors, when you're scrutinizing their conduct, in a position that is implicating a prescriptive rule about what they must do across the board, rather than focusing at the point in time when they have to make a decision.
Right.
When, in this particular case, as I recall it, and I briefly read over the opinions earlier today, just to make sure that I remembered as much as I could fairly accurately, I had the impression when I voiced my opinion that these folks had worked very hard to achieve something for the minority stockholders. I remember that the 2 majority stockholders who signed the voting agreement had their interest entirely aligned with the minority.
Agreed.
There was no special deal for them, no side agreement, no perpetuation of them in authority, nothing. And the circumstances where they had worked very hard to find a buyer, and they knew that treading in the deep woods in the background was Omnicare trying to get what I considered to be a skeleton deal from the bond committee in a bankruptcy scenario to buy the company on the absolute cheap. It didn't strike me that there was any reasonable basis for them to believe that Omnicare was going to pony up.
Right.
And they knew that the only deal they had prospectively, any reality that they could rely upon, would be the Genesis deal. And they worked and worked and worked to pump the Genesis deal up. And in the exchange they had to give for that, it seemed to me perfectly reasonable. And that was, I'll sum it up in one word, certainty. And it was always my view. I've been accused, probably because I'm something of a dinosaur now, as a contractarian. And the truth of the matter is, I am a contractarian.
Deal's a deal.
And I think that in business, certainty in contracting is extremely important. You can't plan without some evaluation from a cost-benefit analysis of the certainty of a deal that you've negotiated in what you believe at the time, honestly, to be in the best interest of the stockholders and the company going forward. I also was very suspicious that even at the very end, Omnicare still had a due diligence condition. And based upon the history, as I understood it, of the relationship between Genesis and Omnicare, and Omnicare basically sitting back like a vulture, waiting to pick the bones of NCS, I fully understood why. I thought the directors did what they did. And I've never been a big fan of bright line rules. I think everything is contextual. And I thought it's a terrible thing for us to be put in a position where we're shaming these people who are unconflicted and who've worked very hard after facing the bondholders losing their money, stockholders getting nothing. They salvaged the debt substantially, and they got something for the stockholders under a scenario where it didn't look like they were going to get anything at
And
the
it
end
was a
of the
certainty.
day. Absolutely.
Condition-free off.
Absolutely. And should they have taken the chance for the so-called superior proposal, even though it was hedged with due diligence?
Yeah.
Should they have taken the chance? I didn't think so. But I understood what the majority was saying. I understood.
Explain it, Your Honor.
Well, I think what they were trying to say is that it's a phrase that one of the members of the majority uses over and over, unremitting fiduciary duties. So you have to keep yourself open to the possibility that there would be a superior proposal. That's part of the duty that you owe. And you've imposed in this situation, under more unitron than unical analysis in my view, a coercive and preclusive, draconian deal where the minority stockholders really don't have a voice. The majority stockholders have already locked up the deal. So the thinking was that part of the fiduciary duty, there should be an ability to accept at all times a superior proposal. You should be able to withdraw your recommendation of the merger agreement that you've already approved when it goes to the stockholders. That was the thinking, but I didn't think it worked here because of the context. For the reasons I've already explained about, I think
The alignment
the
of
two majority stockholders owned 80% of the stock.
Well,
So whatever they wanted to do was going to happen anyway. And they weren't doing something to advantage themselves at the disadvantage of the minority stockholders.
Well, no, they were aligned.
They've been working for the minority
Well,
stockholders.
why would they agree to terms that would limit their ability to get more money unless they thought it was a real deal and the best deal available?
My view was, in their minds, it was, if you believe that enhanced scrutiny, as I always have, is ultimately, however you phrase it,
I never
a
understood
reasonableness test, then you look at every context to see whether the people were conflicted or not, whether they did the job they should have done from the perspective of duty of care, and whether their rationale at the end of the day is reasonable under the circumstances. All of our cases, Revlon and otherwise, talk about not a perfect process, but one that's reasonably going to obtain the objective that on a cost-benefit analysis is the best available at the time. So my thinking was that's what this was. And I was a little perplexed about what I thought was an extension of more of a prescriptive rule.
Yeah.
That you must, in every merger agreement, have a superior proposal fiduciary out.
But, there was language in the merger agreement that, other than saying that the board could terminate it, it did give it terms whereby the board could, under certain circumstances, list another offers,
With a
et
$6
cetera,
million
et cetera.
termination fee. Yeah.
Right. So you look at that, and then I say, well, okay, well, that was almost a fiduciary out, that kind of language. I would read it as such. And what happened in the voting agreement and with the irrevocable proxies, that's being done by shareholders. They happen to also be directors, but they were acting in their capacity as shareholders. And again, you looked at the interest and said their interest is aligned. There's nothing, they're not taking advantage of the other stockholders.
And they're 80% of the shares.
Right, so why shouldn't their decision control the day? But do you think, since the merger agreement did allow for a certain amount of, the board to be open and have other discussions, do you think it was the voting agreement and the revocable proxies that carried the day? Was that it?
Yeah, that's what had to be considered by, I really shouldn't speak for the majority. My understanding of their position was
right.
it was locked up. They resented the fact it was locked up, and they interpreted that as being both preclusive and coercive of the minority stockholders. And there was no discussion in there about appraisal rights, as if they had no other option. But it was, I think, the turning point for the majority. That the minority stockholders really were committed by the majority to this deal, and they really had no effective voice. Not that they would have had anyway, since they were only 20% of the shares.
Well, that's it. And they went into it knowing
Yeah.
that. It hadn't like there'd been some recapitalization or something that took
there
them
was
out
no-
of their
and there's no-
position. But what I also didn't understand was the fact that, again, the proxies and the voting agreements were shareholders versus a third party. I didn't understand, well, maybe you have an idea as to why was the company NCS a party to the voting agreements?
I guess I don't know why the company itself was when
Isn't
the
that
voting
odd?
The voting agreements really were controlled by the two stockholders,
We can't figure that out.
two majority stockholders. I don't have any recollection of that being being
because
discussed or
maybe
thought about.
that made it tied in, because we thought at first maybe it was a 203 issue, but the company in
Well-
their original certificate opted out of that, so we weren't sure. We
Well,
can't
it's-
figure out why they made the company a party to
Well, the
it.
board acts for the company in recommending or withdrawing a recommendation. So I never thought about that.
Yeah.
I know it was, I know it was never discussed. I don't recall it ever being discussed.
Yeah, I just didn't see the need. That was our question, because when you go through all of this, the history, from at the Court of Chancery level and such, it was clear that they said in the voting agreement, the only thing that the company did was made some representations to the effect that, they were the number of shares those shareholders own, what voting percentage that meant, and that it was mere reps and warranties that they were giving. They could have signed the agreement, if at all, just as to those reps. I mean, I wondered if the fact that the company was the party, was that what the majority could look to say that was how the board locked it all up.
I don't remember any discussion along
Isn't
those
that
lines at all.
something?
I really don't. That doesn't mean it didn't happen,
Right.
because I was, as I mentioned, I was very surprised as I listened to the three people who spoke after me, and that they all went another direction for reasons I really didn't fully appreciate.
Yeah, and the majority accepted the findings of fact from
Yeah.
from Vice Chancellor Lamb, and so they had to have understood the interests were aligned and the history of the negotiations.
That's why I
et cetera.
refer to it as imposition of a brand new prescriptive rule that thou shalt always have, consistent with your fiduciary duties, a fiduciary out for a superior proposal under any and all circumstances at all times. And that's what has never made sense to me, having bright line rules in a fiduciary duty common law equity venue. Doesn't make sense to me, because no situation is exactly the same. General principles can be applied,
Right.
but they're always applied, as I understood it, consistently with the facts, and the facts would drive the way in which you applied those equitable principles.
Yes, I've heard you say that before, Your Honor, and that
Well,
makes
it
sense.
doesn't make any difference what I say anymore, but
No,
that's
but
just
at
consistent.
the time when it's still okay,
That's the way I've always thought about it.
counseled it, that you have to look at, is it a good story, is it a bad story? Are there bad facts, and what are they? I need to know about them.
Yeah, and the important one of the important things to me was I'd always been concerned that one of the best things the system can do is attract the best possible people to board service. And one of the things you do not want to do is chill people's desire to be on a board, because, as one University of Pennsylvania faculty member once coined the phrase, by shaming board members, by criticizing what they've done as if they've acted badly.
Right.
When on the facts here,
They-
I could make no determination in my mind, at any rate, they'd acted badly at all. They didn't presciently discover that there was a new prescriptive rule that all merger agreements had to have a fiduciary out for a superior proposal on any and all circumstances, even at the risk of costing you the only deal you had at the time and could reasonably expect to have. They could never have, I think, come to the conclusion that that was going to happen.
And also, your description of, the vulture waiting in the wings. I mean, this kind of decision could dissuade a bidder from putting out their best offer to begin with, because they have to know that somebody else may pop along, offer a little bit more, and that's the end of it.
How many times in the facts did you see the Genesis people referring to the position they did not want to be a stalking horse? They didn't want to invest all this money and time in preparing an
Right.
offer, researching the offer, putting the resources forward to make the offer, and then entering into a merger agreement, only to find out at the end of the day there was somebody sitting back in the wings who had been, in their view, acting deceptively up to that point, and who we know had
Based
been
on the
trying
history,
to cut
absolutely.
trying to cut a deal with the bond committee to get a fire sale in a bankruptcy venue, rather than make a straightforward topping bid. That was the way I looked at it anyway.
Yeah, I have to ask, and basically this is something for my own knowledge. The provision in the majority's opinion, as they described the merger agreement, that the merger agreement said the following: that NCS would not enter into discussions with third parties concerning an alternative acquisition or provide non-public information to such parties unless, the first one was, the third party provided an unsolicited, bona fide, written proposal documenting the terms. 2, the NCS board believed in good faith that the proposal was or was likely to result in an acquisition on terms superior to those contemplated in the deal at issue. And 3, before providing non-public information, the third party would execute a confidentiality agreement, at least as restrictive as the one in place. I read that and said, that's a fiduciary out.
Yeah, well, you're not the only one that did. It may not be totally unfettered,
Right.
but the spirit of it, as I remember it, was that Genesis was not saying under no circumstances can you entertain even the thought of a topping bid during the process. We just have to be satisfied that two things would happen. It would be bona fide.
Mm-hmm.
It wouldn't be conditioned on things
Right.
like due diligence. And it would have to be a good faith decision on your part that it truly was superior.
And so 2 things. Number one, that's why I kept saying I don't understand if there was what arguably is a form of fiduciary out, then it must have been the voting agreements and proxies that tied together with it.
Yeah.
That's what gave the majority angst. But can I ask you, Your Honor, did it surprise you that Genesis gave permission to NCS to talk to Omnicare in, was it September, October? Even though the Board of Omnicare Board of NCS, had not made a decision as to whether or not Omnicare was giving a better offer?
I don't have any recollection of thinking about it, to be honest with you, at this stage. If you ask me retrospectively, would it have surprised me? Probably so, but no.
Yeah, I know.
I don't recall thinking about that.
And that wasn't part of the decisions either.
Maybe I didn't hit the nail on the head in my dissent or in my rationale or my thinking, but I was more focused on what we're deciding to substitute our judgment for that of the board here. And the mechanism for doing is imposition for the very first time of what I consider to be a prescriptive rule.
Right.
And never having been bright line, one size fits all kind of guy, that and the fact that these people who I was genuinely convinced from the vice chancellor's accepted findings of fact had acted perfectly rationally and in the best interest of the minority stockholders, following the dictates of unconflicted board members who just happened to be 80% shareholders who would control the ultimate vote. And even if they wanted to vote for a worse deal, they could have done it. But they all worked very hard to get the best deal they
I
could
agree.
under the circumstances. So that's really
And
where
they
I was
even
focused.
went and even got a waiver from the restriction in the agreement against talking to another party.
Yeah, I,
They even went that step.
I've always been wary of hindsight review, unless somebody has clearly acted in their own interest while serving as a fiduciary at the expense of the beneficiary of the fiduciary relationship. If the facts are clear that that's what's happened, I wouldn't have any problem coming down hard on them
Sure.
and enforcing as strictly as the facts demanded, whatever the consequences proximately caused by that breach of fiduciary duty. But it's very, I was at the time, and I think till the end, I was very self-conscious about knowing that I don't have the business intuitive experience or intellect of true business people. So if I was going to substitute my judgment for theirs, I'd have to be very comfortable with what I was doing. And I wouldn't do it on some kind of, I
Hindsight.
think,
Monday
morality
morning
view
quarterback.
rather than
Right.
business acumen analysis.
Do you think the fact that the order was issued in December and the detailed opinion was not written or at least published until April had any impact? Meaning, if they had to produce a written opinion before
You know,
it explained their order, might have made a difference?
no, I don't think so. I think the majority was understandably quite sensitive to the timing of everything.
Right,
And all the parties were urging action
right.
because what did they want? They wanted clarity. They wanted certainty
Sure.
about what was going to happen going forward. Time costs people, business people, money. I've always liked to think that one of the reasons Delaware is an attractive place to litigate is because the Delaware courts are conscious that time costs people money. And if they can come here and get a reasoned judgment as quickly as possible, that's an attractive factor that Delaware offers in the marketplace. So now, I'm not surprised by that. I can remember 2 or 3 other cases where orders were issued from the bench the same day as the oral argument. I can remember going back in with the court
Right.
when I was with people the most period of time. I don't know how to characterize it. The court after Vesey and before Strine. I can remember going back and we'd discuss what the results should be, and then we'd painstakingly, almost like you were negotiating a treaty with 4 foreign countries, agree on the language that ought to be there, and then go back on the bench, read it to the parties, and then
Right.
say a fulsome explanatory opinion will be forthcoming.
But you understood what their position was at the time the
Oh,
order was issued.
right after the oral argument.
Yeah, you
Well,
knew
there
where
was
they
no-
were coming from.
No, there was no what I would colloquially refer to as a waffle period. It didn't exist. It was pretty clear in the first discussion that we had a 3-2 case. And nobody really was genuinely inclined to move away from the position they had taken. Although, as my entire, however many years it was on the court, I don't know, 13, whatever, it was a very respectful exchange of
course.
opinions. And
Of course.
it was just, we just couldn't come together on it, even though an effort was made to try to talk people into the majority view and even talk me out of writing a dissent at all. But I was
You just
pretty
couldn't.
fired up.
Yeah, you couldn't.
I don't think I wrote a dissent and a separate dissent any other time in my
Interesting.
13 years.
That's it. So
I've
how
joined
strongly
with
you
somebody
felt.
else in a dissent or wrote one that someone joined me. That's the only time I think I ever dissented independently with somebody else also dissenting.
So for you not to be able to be part of a consensus building effort, this
Well,
This made quite an impression to you.
yeah. Well, I was also the junior officer too, so you know, I'm listening to people that have more experience on that court than I had. So
Well,
had at the time.
at that, going back to that point in time when you were the junior officer, I mean, that was quite brave to take such a strong dissent.
I was fired up. There's no question about it. I could have just signed on to Veazey's, Chief Justice Veazey's, and not written it all, but I just had to. I just believed it was important to express myself. Chief Justice Veazey was very eloquent and very well-founded in the law. Mine was more focused on how can this be happening?
Right. This is
It just
crazy.
doesn't seem right to me that these people should be criticized like this, because I don't think they've done anything wrong. I don't think they have breached their fiduciary duty. Now, admittedly, breaching your fiduciary duty isn't committing manslaughter, and I understand that. But again, I think it's the kind of professional criticism that should only occur when it's mandated, when there's really bad action.
Not when there's a record such as there was here of
not-
all
not-
the work done by the board.
Not under these circumstances. You could make the case that reasonable people could have handled it differently, but the way they handled it under the circumstances, as I saw it, was very reasonable.
So this is still law.
Oh yeah, yeah. It was. I think Chief Justice Veazey was very wise when he referred to it as sui generis, that there'll never be a fact situation anywhere close to this again, and that people will conform to what this new rule requires. But the real question was whether there needed to be a new rule and whether that conformity should have been mandated by the Delaware Supreme Court, and the risk it put into the system because of its lack of certainty.
Makes everybody a stalking horse who comes
Well-
to the table first and gets a deal.
Well, the fact that it's never, a situation has never occurred again that gave rise to re-examining Omnicare pretty much says it all about the marketplace's ability and the bar's ability to work through what might have been considered at the time something of a surprise change in the law.
So, given these circumstances, do you see anything inappropriate with a merger agreement with this type of provision in it, and combined with the majority stockholders whose interests are aligned entering into voting agreements and giving proxies?
Well, the cases, the opinions talk about the old, as someone referred to it recently who will remain unnamed, the old saw, Schnell, that just because it's legally possible to do it doesn't mean under the circumstances equity will allow you to do it, because it may be inconsistent with your fiduciary duty of loyalty and care. So I do agree that this case is truly unique, and that it's hard to imagine that a similar set of facts would occur again. I don't know what the future may bring, but it is quite remarkable that there's never even been a discussion in a case of which I'm aware about whether Omnicare should be revisited.
No. And I suppose my question is, maybe this is too technical, but if NCS had not been a party to the voting agreement and what went on between the majority shareholders and Genesis, the board was not privy to or didn't have to approve anything or become a party to, do you think the result would have changed?
There's so many little comments in the majority opinion that made me scratch my head. Like,
Good.
the board didn't read the entire merger agreement. They relied upon a synopsis of it, or a summary. I think summary was the word used. Well,
Yeah.
does a board read an entire merger agreement, or do they rely on counsel to explain and to answer any question they might have after they read it. But
Right.
I thought that was meant to be somewhat damning, but it didn't rise to the level of a lack of a breach of the duty of care. It wasn't as if they didn't understand the import of it and
Right.
what the consequences would be down the road. After all, these people have just engaged in what, and I viewed at the time and still do, as a major salvage operation, as much as anything else, and could have relieved themselves by knowing that they had taken a disaster and made the best of it under
Absolutely.
the circumstances. That was the way I was looking at the way they had conducted themselves, not whether they admitted that they relied on a summary of the merger agreement as opposed to reading the therefore clause and the hereinafters and the but-fors and all the rest of that. That didn't seem to be important to me. But what do I
Again,
know?
they're businessmen.
You can't rely too much on the quality of your view when you're a dissenter. I mean, you're dissenting, and the law is not what you think it should be, and has never been what you thought it should be from that day forward. So it's pretty hard to put great reliance on your own view.
Wow, that must have been hard.
Well,
Because still, and then you move on to being Chief Justice.
well,
and
yeah,
you respect the institution. It's hard.
well, trust me, it wasn't like I was at the crosswalk checking out everyone who walked across the street to see if this was my chance to reverse, to change Omnicare.
Right.
What's the word? There's a magic word for it. Help me out here, Larry. What's the magic? Overrule. That's the word I'm groping for, yes.
I understand. Is there something else you want to share with us that your thoughtful dissent and your comments today, beyond what we see in the record, that you'd like to share with us? I, for one, enjoyed the way in which you discussed how the justices meet to try to come to some consensus, or the junior officers
Yeah,
starting to the senior.
I'm not sure
and you-
that's still the case, but that's
That's how you-
that's the way we did it when Chief Justice Veazey was presiding. It was carried on through November of 2013. I can't speak to how it's done now.
Is there anything else you'd like to leave us with that's...
No, I just want to thank you for giving me the opportunity to have to indulge in an Alka-Seltzer this early in the year.
I'm so sorry, Your Honor. Notice I'm still calling you Your Honor. I mean,
Well.
habits are hard to break. But thank you.